This is The Law Show on CL 650. Now back to the show.
Yeah, we're talking about estate law and estate planning here on CL 650. I'm Zach Spencer with John Lakes and John White from LakesWhyteLLP in North Vancouver. And we've been talking about trusts for underage children, for adult children, for spouses. And if you're a trustee, what kind of fees can you charge against the estate?
Well, you can, under the Trustee Act, you can charge up to 5% of the gross value of the estate for fees, plus you can charge a management fee and so forth. Generally speaking, depending on the nature of the estate, it may be 2.5%. If you use a trust company, they'll want you to sign an agreement setting out the fee. Now, but your fees you can also claim your out-of-pocket expenses too, but at some point in time, before you can pay yourself fees, you have to have your accounts approved by everybody who's a residual beneficiary, and that has to be 100%. And then if any of the beneficiaries are either under the age of 19 or mentally competent, your accounts have to be approved by the Supreme Court of British Columbia before you can pay yourself executor's fees. So sometimes there'll be a provision in the will setting out provisions of the fees, but so when someone acts as a trustee, it's important they keep a record of all their time and what they've had to do and so forth. So for a typical estate, maybe it's 2.5%. To get 5%, it usually involves litigation, may involve, shutting down 3 or 4 homes owned by a hoarder, maybe dealing with CRA and things like that too.
Yeah, Zach, I just want to add to that. The whole scheme of being a trustee or an executor is that you're really not supposed to be out of pocket by doing so. So
people must fall into that all the time, where they feel guilty taking money from the estate, or is that happen?
Or they worry about sinking their own money into estate purposes while they're waiting to have access to estate monies. And it's important to realize, fees and essentially out-of-pocket expenses are likely to be treated differently. You're supposed to get all of your fees back as long as they're reasonable. You should be getting that back dollar for dollar. The executor's fees that John is talking about is on top of your expenses, and that is to compensate you for your time and trouble in administering the estate.
So that's a fee for doing the job, excuse me.
Yeah.
Yes.
Okay. Not just your expenses.
Right.
And that's separate than if you may be a beneficiary as well. So the difference, though, is anything you receive in a will is tax-free. However, whatever you receive as the executor's or trustee's fee are included within your taxable income.
Oh, okay.
Yeah. It's another job.
So if you're somebody like yourself, a professional, you're both lawyers, your time is worth substantially more than somebody who, is a tile layer, for example. What? So how do you determine what is a reasonable rate for your fees?
Okay, well, that's a very good point, because if you appoint a professional person, a lawyer, an accountant, they're supposed to be, like, for example, the lawyer's an executor, which not many lawyers like doing that.
I'm just
anymore,
saying that this is a personal situation.
Yeah.
You're not doing it as a lawyer. You're doing it as a family member.
I would keep 2 accounts. I would keep my time as executor separate from my time as a lawyer.
Right.
Yeah, it's a good idea for executors to keep a record of their time in case the court is going to look at just how much work they had to do in order to earn their executor's fees.
The point I'm getting at is, would you bill it as the same rate as you would as an attorney?
Well, that's not really done that way in most cases. It is, and we've talked previously about something called a charging clause that can be put in your will, where you actually appoint someone who's a lawyer or a notary or an accountant, somebody like that, to be your executor, and you provide that they can charge their time out essentially at their professional rate.
Right.
If you don't have a clause like that in there, then they can't, and their executor's fee is going to be calculated based on the value of the estate, not on what their hourly rate happens to be.
Back to the 5%, or more than likely 2.5%.
That's correct.
Okay, so let's get into the signing of the will, because it sounds so basic that you have this document, you spend all this time, and you sign it, and it's done. But there are basic rules around this, and they're really quite specific. And if you don't do it properly, it can be a headache, right?
Well, the rules, we have a law called WESA, Wills, Estate Succession Act, which is actually having its 2nd anniversary on March 31st. So, right. And it sets out the rules for a will. So it may seem trite, but for a will to be valid, it has to be in writing, It has to be signed at the end by the will maker, and it has to be acknowledged by and there has to be 2 witnesses who see that person sign the will, and then they have to see each other sign the will as well. So there has to be 3 people present at the time. Now, if somebody is legally blind, or else if they're, they will have the will read to them, but they still have to sign it. If somebody doesn't understand English, they will have the will translated to them, and they can sign it as well too. But where a will is not valid is, let's say it's one of these wills you do yourself, where you sign it in front of your neighbor Mary, and then you go across the street and get your neighbor Frank to sign it.
They didn't all witness it, though.
That's not valid under the Wills Act.
Yeah,
it's
just as it astounds me, really more than I think any other area of wills law, just how many cases there are about wills that aren't signed properly. The rules that John just set out are really, really simple. I mean, will's got to be in writing. You gotta, if you're the will maker, you gotta sign it at the end. You gotta have 2 people witness that, or at least witness you acknowledge your signature, and they've got to sign it while they're sitting in the room with you. Mm-hmm. How hard is that? You might ask. And yet there are all kinds of cases where there are variations on this thing. John just talked about one.
And then there's a digital component. Say you write the will, and or say your lawyer sends you a copy of it, and you say, yeah, that's fine, that's good, I agree to that, and you think that's it. Well, I'm not saying a lawyer, but I mean, but that's not going to hold up,
well,
right?
I just want to clarify, because Wes has changed things a lot, because until March 30th, 2016, if the will wasn't done this way, it was not valid. We talked about previous shows about a thing called a testamentary document. It could be that it may be recognized as a testamentary document if it's not signed properly. The other big change is that until March 31st, 2014, if a witness to a will was either a beneficiary or a spouse of a beneficiary, the will was still valid, but the gift was void. So let's say you leave $25,000 to your brother Frank, and Frank or Mary witness your will, then under the old law, that gift was void.
Because they were a beneficiary.
That's right. Now under the new law, and there hasn't been any cases yet, it's voidable. So it's possible that on the face of it is a void gift. However, the argument may be that your sister-in-law shows up, or your brother-in-law says that, well, all I did was sign Zach's will. I had nothing to do with Zach signing the will. I didn't even read the will, and therefore this was an innocent mistake. Please give me that money. We're still waiting for the first case saying that, but it is a saving grace. But
is it often the mistake that a husband and wife have wills, and they witness each other's wills, but in essence they're both beneficiaries from each other's wills?
I haven't seen that.
Oh, okay.
Where I see it is usually that it's a brother or sister, and they know they don't get the brother to sign, but what they do is they get their sister-in-law to sign. And so the witness has to be over the age of 19, and they're confirming the person's capable and they were sober. But the other thing is you have to get not just the witness's signature, but you need print their name and their address, because at some point in the future, if the will is being contested, you have to find those people who witnessed the will. So it's one thing if you have a lawyer, or you can usually find that person, but if you're in a care home or something and you just get 2 people to witness it, and then 2 years from now someone's challenging the will, if you can't find the witnesses, you got a problem.
Zach, just getting back to a point you raised earlier with the electronic will, or the email, I guess, that goes back from the will maker to his lawyer to say, yeah,
I'm good with that. Yeah,
I'm good with that. I'll come in and sign it next week, and then dies on the way.
It's not funny, but yeah.
Yeah, but these things. I mean, everything that you can imagine happening has happened.
Right.
Just in terms of fact scenarios. But the law would treat that potentially differently than it would have before we brought in this new law, what John called WESA, the Wills, Estates and Succession Act. Before the end of March of 2014, almost exactly, well, this is a little more than 2 years ago now, that person would have been out of luck. Basically, that would not have been a valid will because it hadn't been signed.
But
period.
you would go to court and you would say the intent was.
Yeah, but that before the new law came in, that would not have passed muster. Our Court of Appeal ruled, in keeping with past practice, that there's no such thing as sort of substantial compliance or close but no cigar with wills. You either comply with the execution requirements of the Act or you don't. That used to be the law, and it still is to a degree. But we now have this curative provision we didn't have before. It's Section 58 of the Wills and Estates and Accession Act, where if the court is presented with what is something that's not qualified as a will because it hasn't been executed or executed properly, but it is a record, which can include an electronic record. They've got specific rules for that. If the court is persuaded that this record, whatever it is, represents the testamentary intentions of the will makers, what they meant to do.
So in that situation,
they can allow it.
So you send me. You're the lawyers representing me. You send me this will. I say, yeah, I'll be in tomorrow at 2 o'clock. I'm going to come and sign it. Everything looks good. I'm good to go. You send the email, and as you say, you get hit by a bus and you don't make it there. You can now go to court and say, well, he said, yeah, that's good to go. I'll be there tomorrow to sign it, and you might get that through.
I think that argument's open. I mean, we haven't had a case
situation like that,
at least not that I'm aware of. We have had a case recently. I think it's still the only case, and certainly the most prominent one on this area. But it's one where the woman signed a will, and that was fine, and then signed a couple of other documents afterwards, or she drew up a couple of documents afterwards. She signed the first one. She didn't sign the second one. And the court took that first one that she signed, but it wasn't signed properly as a will because she just signed it herself, and concluded after looking at all the evidence that yes, that signed document represented her testamentary intentions.
So that was
and
the closest to the
Yeah.
intent, right?
But you can. But the court didn't allow the unsigned document. It was essentially
so what
a
would have
laundry
happened
list.
in the past, from 2 years ago? It just would have said, okay, we're just
No will.
It's wallpaper.
Okay.
Yeah, it's not worth the paper it's printed on.
So you think this is better?
Well, if our objective is to try and mirror as closely as possible what the will maker intended, yeah, I think it's potentially better because it gives the court the opportunity not to fall prey to just formalism, but actually to look at all the evidence
and inject a bit of common sense.
In the right case, they can inject the common sense necessary. And I think that example of the email that can be shown in court to have been approved by the will maker, not his wife or his kid, but the will maker himself, I think there's going to be a case where the court is going to allow that. The legislation provides specifically for electronic records. And so I think it's going to happen. All
right, well, we're going to take a quick break. When we come back, we're going to get into a couple of different cases that you want to talk about with signing of wills because it's vitally important. We'll pick that up next. We are talking a fascinating subject today, what you should do when signing a will. It sounds so basic. You sign your name, but it's not. When we come back next on The Law Show here on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.